case is Wallmuth versus Rapides Parish School Board on pages 666 through 669. This is a especially interesting case to me because I am a PE teacher right now, and this involves a PE teacher. So, citation, Supreme Court of Louisiana, 2002, not too long ago, and the decision is that the school board is not liable for injury to student in locker room fight when teacher was not present. So what happened was Joshua Wallmuth was an 8th grade student who was attacked by 3 students, kicked by one of them, in a physical education class in the back corner of a locker room after class during dress time. One student had threatened Wallmuth during class that he would get him. Wallmuth testified he thought the threat wasn't serious and felt no danger or harm going into the locker room after class. He thought the boy had cooled off. Wallmuth claimed the kick severely injured his knee. 30 to 60 seconds after the incident, the PE teacher came into the locker room on his regular patrol and found Wallmuth on the floor. Initially, the trial court found the school board 100% liable for Wallmuth's injuries because they felt that the school failed to supervise students adequately. The Court of Appeals found the school board 70% liable for Wallmuth's injuries due to unreasonable supervision. More facts. Wallmuth testified that the PE teacher was not there when he was being attacked and hardly ever supervised the locker room. Wallmuth also claimed that there were lots of locker room incidents, 10, previous to this one directed at him, and the PE teacher never saw them. He admitted he never told the PE teacher about them and didn't tell the PE teacher about the in-class threat prior to the incident. 2 of the 3 accused students admitted that they were horseplaying with Wallmuth for a few minutes but were not mad at him. They also said that the PE teacher did come into the locker room to supervise often. The principal didn't recall any incidents in PE class and testified that the PE teacher always received the highest ratings on the evaluation each year. Facts continued. The PE teacher testified that he had 3 areas to supervise: the gym, the locker room, and the canteen, all at the same time. And he would come into the locker room every time students were changing and would walk to the back, but admitted he couldn't see the back corner from where he was when the incident occurred. The PE teacher admitted there had been about 5 fights that year, none of which resulted in serious injury, and he couldn't do anything to prevent them. 3 other students testified with Wallmuth that there were fights in the locker room every day, but they never told any teachers. So, the issue at hand here, the question is whether the lower courts erred in finding the school board liable for Wallmuth's injuries. So, the Supreme Court reversed and rendered the lower court decisions and dismissed Wallmuth's claims against the school board. Why did they do this? The legal rationale for the Supreme Court decision is as follows. Before liability can be imposed on a school board for failure to adequately supervise the safety of students, there must be proof of negligence in providing supervision and also proof of a causal connection between the lack of supervision and the accident. Also, before a school board can be found to have breached the duty to adequately supervise the safety of students, the risk of unreasonable injury must be foreseen, constructively or actually known, and preventable if a requisite degree of supervision had been exercised. So, as we continue, legal rationale, the reasons why the Supreme Court decided that the school board was not liable was that they felt the school couldn't foresee and prevent the incident. For the following reasons: the teacher didn't know about the threat, the action of the 3 attackers was unforeseeable, the incident happened suddenly, no prior history of violence between the boys was known, even Wallmuth testified he didn't feel threatened going into the locker room, and he thought the boys had cooled off after the in-class threat was made. Wallmuth didn't tell the PE teacher about the posed danger. There's no way the PE teacher could have foreseen or prevented the incident. The PE teacher and the principal had no prior knowledge of rough housing in the locker room. The PE teacher had no more reason to be in the locker room supervising than he did to be in the gym or canteen areas supervising. Constant supervision of all students is not possible or required for educators to be adequately supervising students. Thanks, that's all.